Hello, this is Matt on the Moon Lambeau channel. About 24 hours ago, I published a video highlighting interesting and concerning discussion within the XRP community. That was a result of a legal development in a Ripple lawsuit, but not the SEC lawsuit. It had to do with a new trial coming up here. But the new trial actually stems from a very old lawsuit, which was actually filed back in 2018 as a class action lawsuit. Now, as it turns out, that Ripple actually won massively there, so it's not completely over, and it'll get you all caught up to speed in the early part of this video and get straight into the new stuff. So, you know, on all the stuff that's most consequential, Ripple actually did win, but there was a lot of confusion going on, and understandably so, based on what happened, because, you know, there's going to be a jury trial. Part of what the jury is going to be considering is the legal status of certain transactions and the Howey test and how it applies to XRP, which again, understandably confused a lot of XRP holders. And I myself, upon seeing this news, I was like, well, I need to seek clarity, because there was a particular perspective from a well-known and reputable member of the XRP community who is an attorney, and he expressed concern that you could have a situation where XRP itself is found to be a security in the state of California, but not a security in the state of New York. And then I found perspective from another XRP community member who is also an attorney who seemed to not completely agree. And so I kind of did get to the bottom of that, and I'll just set the table in case anybody missed that and needs to be caught up to speed. I'll take care of that as quickly as possible in the first part of the video. But suffice it to say, the next day, which is today, Ripple CEO Brad Garlinghouse, as well as Ripple Chief Legal Officer Stuart Alderite, came out, and they made sure to set the record straight. And just to be clear, what they're stating, and I'll give you their exact statements, but the legal status of XRP as a result of what's happening in this 2018 case, which is actually going to trial, separate from the SEC lawsuit, it does nothing to change the legal status of XRP. And I will go ahead and explain why. But before going further, I do want to be clear, I do not have a financial background of any kind. I am not offering financial advice, and you definitely should not buy or sell anything because of anything I say or write. I'm just an enthusiast who enjoys making YouTube videos about crypto-related topics, but just as a hobby and just for fun. All right, so let me quickly get through just a few important pieces that you really do need to be aware of in order to be fully informed of what's going on and why so many people in the XRP community were concerned about the legal status of XRP as a result of the most recent legal development. So there's this story from CoinDesk yesterday titled, "California Judge Dismisses Part of Civil Lawsuit Against Ripple, Sends Rest of Securities Case to Trial." And so in my video about 24 hours ago that I published, I ran through this article. And so I'll just say this. You know, the CoinDesk headline is misleading. And so they did cover facts of the case, but the thrust of the story should have been different. It should have focused on the developments as a major win for Ripple. But of course, surprise, surprise, CoinDesk, there's a reason we in the XRP community call them FUD desk, because all they do is tilt news in a negative way when it comes to Ripple and or XRP. Whatever the news is, if they can slant it in a way that makes it sound more negative for either Ripple or XRP, that's what they do. They have a notable bias, and it's been highlighted explicitly by XRP community members for the entire time that I've been here, which is since late 2017 I've been here. So they're doing the CoinDesk thing. They just are. But despite that being the case, there still is concern put forth from attorney Fred Rispoli of the XRP community member, and I do want to quickly share with you what he had to say. So in response to this most recent legal development, he said, "Win for Ripple in the Oakland class action." So I'll pause, and of course that is the 2018 lawsuit, the class action lawsuit, which is going to jury trial. But anyway, he said, "Win for Ripple in the Oakland class action. Judge grants Ripple's summary judgment motion on federal class claims for unregistered securities, as well as the state law securities claims. But these were procedural wins. The The class action is now over at the district court level. As to whether XRP is a security, however, the court held it is for a jury to decide whether all three prongs of the Howey test are met. That claim, an individual claim by one plaintiff, will go to trial. In all likelihood, will settle given the extremely low damages and very bad jury verdict that could result if plaintiff wins. To sum up, court says whether XRP is a security in the context of retail buyers on an exchange is for the jury to decide and not a matter of law. Ultimately, crypto world needs to keep pressure on getting federal legislation because we are on track to having XRP be a security in California, but not in New York. And so that last part right there is what really caught most people's attention. He's saying there's an actual chance that XRP itself could be a security in California, but not in New York. And so the reason that the Howey test needs to be applied to XRP, this is my understanding at this point in time, and I think I have this correct. If not, somebody feel free to correct me in the comment section below, but I think this is accurate. It's because of a 2017 statement Brad Garlinghouse made when he said that he's very, very long XRP, but he was selling XRP at the time. Now, I said my spiel on this yesterday, so I'm not going to repeat it in this video, other than to say I have no problem with him selling assets that he owned. It probably became an outsized portion of his overall net worth. It's part of his compensation package when he got hired at Ripple. It's none of our damn business anyway. I don't care if he's selling it. But he was selling while saying he was long XRP. And I'll tell you, I can be long XRP and sell a portion of my stash. You could do that too. So these things are not somehow mutually exclusive. But if you're going to get to the part where you're going to rule on that, you have to know whether or not there were illegal securities transactions, and that's why the Howey test would be applied to these transactions. So that's the point right there. Now, of course, you can understand why there would still be confusion, but what about what Judge Torres ruled on? And so attorney Bill Morgan, another member of the XRP community, said it would be sales of XRP, not the token itself, that they would be applying the Howey test to. That's the point that he was making right here. And so, okay, so that's good clarification right there. But still the question remains, what did this actually mean for XRP holders? And I did ultimately, after a lot of questions on social media platform X and searching for answers from attorneys that I follow on the platform, I did get to the bottom, at least to the point where I could understand, is there actually something that we should be concerned about as it pertains to XRP? And here was a post from a former SEC attorney, Mark Fagel, responding to a post from me, and he shared his thoughts on this. He says, I wouldn't overstate the issue here. The California case alleges securities fraud by a Ripple executive. While the court must first address whether XRP was sold as a security to reach the fraud issue, the case will not result in the same sort of relief the SEC seeks in its case. So even an adverse finding for Ripple may have no broader implications. At most, Ripple might decide not to sell XRP in this district. So that's the key takeaway here. You look at what he wrote here. Again, the California case alleges securities fraud by a Ripple executive. So even if that is indeed found to be the case, they're not ruling on anything else having to do with XRP. So even if they have to rule that there are certain transactions applied to XRP that would have been illegal, so they can rule that Brad Garlinghouse made a bad statement. Even if they do that, that's on a district level, it would apply specifically to that part of California. And so it's completely inconsequential anyway. And that's a former SEC attorney acknowledging that is indeed the case right there. So ultimately, nothing to worry about for the average, typical everyday XRP holder. So it took a lot of searching and a lot of asking of questions to get to that point, but we did ultimately get here. Now, even though that is indeed the case here, and we really don't have anything to worry about as XRP holders, because again, when you're talking about the SEC, that was a separate case in New York, and they were asking for all sorts of stuff that absolutely would have squashed XRP, but here, the class action was already thrown out, and you're talking about, again, one charge remaining having specifically to do with a comment from Brad Garlinghouse in 2017. That's all that's up for grabs. So even if they have to find certain transactions having to do with XRP, we're illegal. It doesn't matter. Doesn't change anything. It doesn't, quash the, what Judge Torres had to say about XRP. It certainly doesn't override it. So no, we don't have to worry about that. But still, Brad Garlinghouse and Stuart Alderati, understandably, not so happy with crypto media. Take a look at this. So here was the post from Ripple Chief Legal Officer Stuart Alderati. And he said, he shared the CoinDesk article, which I just highlighted earlier in the video, and he said, to be clear, the California judge dismissed all allegations suggesting that Ripple violated federal securities law. The New York ruling that XRP is not a security stands undisturbed. One state law claim based on a 2017 statement is going to trial. So I'll pause. That's what I was highlighting before, that statement Brad Garlinghouse made about being very, very long XRP while selling XRP. That's what we're talking about there. And then Stewart says, the plaintiff, who didn't buy directly from Ripple and can't say if he even heard the statement before he traded, allegedly lost a couple $100. We look forward to that cross-examination. My God, if that actually happens, what I would pay to see that. At least $1.05. I'd pay at least $1.05 to see that if I could witness that firsthand, because that would be a ride, man. It's like, get your popcorn ready, son. But this guy, so again, didn't buy from Ripple, and he doesn't even know if he heard Brad Garlinghouse say that he was very, very long XRP, and it was just a couple $100, and he still sued. See, that is frivolous. That is to me, that's my humble opinion. That sounds ridiculously frivolous. This was an attempt to grab money. It's just a money grab. That's all this is. So far as I'm concerned, it's completely bogus. Now, I will note this link from the CoinDesk post was deleted, or from CoinDesk. It was deleted. So I think it was deleted by the first time I had seen this in the morning, but CoinDesk, they probably thought they're probably getting some steam from this, and they're like, yeah, we're just gonna go ahead and delete that. So it's what it is. That was reposted by Brad Garlinghouse, and he simply wrote CoinDesk sigh. Yeah, pretty much. Facepalm also. And then in a separate post, Brad Garlinghouse expanded on a bit on what was going on here, because there are all sorts of crypto media outlets with some not so intellectually honest headlines, let's say. And so Brad wrote the following: as many have noticed, and some have already pointed out, there have been numerous misleading and some factually inaccurate headlines describing the decision made by a California judge yesterday in the class action lawsuit about XRP. I'm happy to see some correcting them. I wish I could tag/link them all here. And so I'll pause and note, as far as the CoinDesk headline, I think this is the same as what I reported 24 hours ago. I mean, I guess I didn't technically double check it before recording this, but I don't think they changed a damn thing. I'm not seeing that it's to the best of my recollection, this is the title from 24 hours ago. But it's CoinDesk. I wouldn't really expect them to change, facts, whatever. Who cares? What matters most to CoinDesk is how CoinDesk feels about XRP, and they want to FUD the hell out of it. That's what they do. That's what they do. Anyway, Brad Garlinghouse continues. To be absolutely clear, this is a big win. All class action claims in the suit were dismissed, and absolutely nothing in the decision negates or changes the fact that XRP is, in and of itself, not a security, per the New York court decision. The California ruling dismissed all allegations that Ripple had somehow violated federal securities law by selling XRP. As for the single state law claim that will now be scheduled for trial, the sole plaintiff didn't buy XRP directly from Ripple and can't say if he even heard the statement before he traded and only owned a couple hundred XRP. This was a clear example of the trolls that unsuccessfully tried to take advantage of the U.S. legal system and distort statements to seek hundreds of millions in class action settlements. And lastly, regarding any misleading statements, I stand by what I said and am looking forward to shedding light on that during the trial. Yeah, he's spot on, and I'm glad he's calling it out like it is. Yeah, that's a great characterization. I mean, this is a guy who bought XRP when it was near its all-time high over 6 years ago. And I believe he held it for all of like 2 weeks or so, sold it at a little bit of a loss, and then decided to sue. Class action law. It's completely absurd. So that's what we're working with here. But the good news is, we, as XRP holders, have nothing to worry about. It's totally different than the charges that the SEC set forth in the SEC v. Ripple case, and in terms of what the SEC was asking to have done, and all that jazz. It's not even close to the same realm. Nothing to worry about here. But I totally understand why there was confusion. And in fact, after seeing what Attorney Fred Rispoli wrote, I was very curious as well, because again, when he said that XRP could be a security in California, but not New York, I was very curious, because I'm like, well, the asset itself isn't a security ever, right? I mean, it's unless it's included in the definition of what that is. Like, for instance, a stock is always a security, but cryptocurrencies or digital assets, they're not included in that definition. So I was kind of curious about that anyway. But so far as what we've seen from Brad Garlinghouse and Stuart Alderati, they're saying, nope, there's literally nothing to worry about here. Everything is fine. So that's what I got for you now. Hopefully that's the end of this particular story. But if there are any additional developments, I'll be happy to report on it in a future Moon Lambo Hot Jam. I'm not a financial advisor. You should not buy or sell anything because of anything I say or write. That would be a very, very, very bad idea. Until next time, to the Moon Lambo.